When parents go through a divorce, things can get complicated fast, and unfortunately, grandparents sometimes get caught in the middle. It's not uncommon for one parent to limit or completely cut off access between the child and the other side of the family. That might mean a mother keeps the kids away from their paternal grandparents, or the other way around. So, where do grandparents stand legally? In Ohio, everything comes down to one core idea: what's in the best interest of the child? Ohio law does give grandparents certain legal rights, but those rights aren't automatic, and they're not unlimited. When a court looks at whether grandparents should have visitation, it considers a specific set of factors. That includes things like the wishes of the parents, the child's age, and how well the child is adjusted to their home, school, and community. The court will also look at the child's relationship with parents and other relatives, how far the grandparents live from the child, and how much time everyone realistically has available. If the child is old enough, the court may even consider their wishes. Health and safety are obviously a big factor too, along with the mental and physical health of everyone involved. The court will also look at how much time the child has with siblings, and whether the person requesting visitation has any history of criminal offenses involving child abuse or neglect. Now, if a grandparent is denied visitation, the court doesn't have to explain why, but in some cases the judge may issue a written explanation, and if they don't, you can actually request one. That's called a finding of fact and conclusion of law. Let's go through some of the most common questions grandparents have. If your son or daughter is going through a divorce, do you have visitation rights? The answer is yes, potentially. Grandparents can file a motion with the court during a divorce, dissolution, legal separation, or annulment. If the court determines that visitation is in the child's best interest, it can grant those rights. What if your son or daughter has passed away? In that case, grandparents can still request visitation. Ohio law specifically allows grandparents of a deceased parent to ask the court for time with their grandchild. What if the child's parents were never married? Grandparents can still request visitation in that situation too. Whether it's the mother's parents or the biological father's parents, the court will again decide based on what's best for the child. Now, what if the child has been moved to a different location? Visitation requests generally need to be filed in the Ohio county where the child lives. If a case has already started somewhere else, that court usually keeps jurisdiction. What if your grandchild simply doesn't want to visit? That's something the court will take into consideration, but ultimately, the judge makes the final decision. A lot of grandparents also wonder about financial responsibility. The good news is no. Grandparents are not responsible for child support. That obligation stays between the child's biological parents. Another concern is medical care. If your grandchild is injured while visiting you, can you get them treatment? Yes. If you have a court-ordered visitation agreement, you're allowed to seek emergency medical care for the child while they're with you. Now let's talk about custody. Can a grandparent actually get legal custody of a grandchild? In some cases, yes, but it's not easy. The court would have to determine that the child's parents are unfit. That could mean issues like chronic substance abuse, abandonment, or other serious concerns that affect the child's well-being. What if your grandchild doesn't live in Ohio? In that case, the child's home state has jurisdiction. Every state has different laws, so you'd need to look at the rules where the child actually lives. And what if your grandchild is already living with you? There are legal options for that too. If the parents can't be found, a grandparent can complete something called a caretaker authorization affidavit. That allows you to handle things like school enrollment and medical care, but it's only temporary and not the same as legal custody. In more common situations, where the parents are involved but the child is living with grandparents, a parent can grant a power of attorney. That gives the grandparent authority to care for the child's daily needs. Depending on the situation, both parents may need to sign off, especially if they're married or there's an existing custody arrangement. At the end of the day, these situations can be emotional and complicated for everyone involved. If you're a grandparent trying to understand your rights, it's important to get clear, accurate guidance so you can make the best decisions for your family. Call me. The case review is free.